Kathy, Deshaun Johnson. I'll show bench one.
Okay, thank you.
What other matter you?
I have Orban and McDermott. However, Mr. Hannah just told me that Mr. McDermott is downstairs, not over Polycom, so I need to go talk to him for just a couple of minutes.
Sounds. And Orban is not. That was just a review though.
It was a review. She on Tuesday, or I'm sorry, she had a hearing on Monday and Tuesday. She appeared for one and not the other because she got her dates mixed up. We reset one of those dates for January, the one she did appear for, because she finally got her birth certificate that she's been waiting on for her license.
What was it review for?
I think it was to check in to make sure that she was going to appear for the other date this week that she hadn't completely disappeared on us, that she had just mixed up a court date.
Okay, so we'll reset this one.
Thank you very much. I appreciate it.
After January. Yes. Yes. I was trying to see if the other one was a ordinance case. It'll be January 27th at 10. Okay. Mr. Johnson is here on Hill.
That's correct, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Alyssa Hill, 24-03482. Appearance, please.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning. May it please this honorable court, Kareem Johnson, on behalf of Mrs. Hill.
Okay, today was the date that was scheduled for probable cause conference. And this is for armed robbery. Matter is scheduled for preliminary examination. Actually, I don't think it is scheduled for preliminary examination. We need to reset one if one is going to continue. Was there an offer on this?
There is an offer on this file, Your Honor. One moment. The offer would be to plead to a felonious assault with a reduction from a half third to a half second.
Okay, are we continuing to exam, counsel?
No, Your Honor, we'll be asking the court to accept the waiver of the preliminary examination.
So that's what you want to do? You want to waive your preliminary examination?
Yes, ma'am.
You understand that you have the right to require the prosecution put forth evidence at the time of their preliminary examination to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am.
Do you wish to unconditionally waive your examination?
Yes.
Anybody threatening you to do that?
No.
Any promises being made to you if you waive your exam?
No.
You understand that the waiver is unconditional and you can't later change your mind if you get to circuit court and things don't work out the way you thought. You can't come back and say you want to have your exam. You understand that?
Yes, ma'am.
Find your waiver to be freely and voluntarily given. Your bind over date is going to be. I say it was the April. Yeah, that's the first is a Wednesday. Okay, January 8th. That's the date the circuit court will get the file from the district court. You do not need to appear in court on that date, okay?
Okay.
Your next court date will be a pre-trial. Your attorney will be made aware of that. Any additional matters for the record?
Just so the record is clear, Your Honor, the people would also be unconditionally waiving their right to an exam on this side. Nothing further.
Thank you.
Yeah, and I'd like to address my client's bond.
Proceed.
Your Honor, this case will be resolved in circuit court. You know, we will be humbly asking for a no habitual plea, but either way, this is a charge as an armed robbery. And, you know, technically, based on the accusations, it will be an armed robbery that arose out of a retail fraud. You know, my client will not be offering any excuse or justification for what happened on that day, but I do not believe that she's a flight risk or a danger to the community at large. I believe that the court would allow her to have a $10,000 cash surety or 10% bond with no contact with any Meyer, possession of no weapons, and checking in with pretrial services. The court can ensure that she one, doesn't offend any law of the state of Michigan while on bond, and two, that she appears in court, Your Honor.
I have no objection to that request, Your Honor. I think the analysis there by Mr. Johnson about this really being a retail fraud and technically turning into an armed robbery is there. I'll leave it to the court's discretion. I have spoke with the victim on this matter and they haven't expressed any safety concerns, so.
I don't have criminal history, which Master Moore had when she arraigned the defendant. And obviously took that into consideration when issuing a 50,000 cash surety bond. Of course, this charges of armed robbery, habitual third offense notice. I don't really, was she on probation at the time?
It's entirely possible, Your Honor. The last conviction that I see is for resisting and obstructing in March of 2024.
The record, I'm gonna review her criminal history. So you want to adjourn this exam till when, March?
I didn't see what date you put in there. Is that what?
Well, it's not available. Oh, okay, well, it's not likely we have any, it needs a full day. It's not likely we have anything in January. I was waiting for, I gave you a file for criminal history.
I don't know if I had the ability to sign
We
up.
can go get it from, you can go get it from, Marquita. Marquita can print it. All right, thank you. Mr. Carter is on Glasgow. And then, let's see, Mr. Yang is here for Ariana Ashe. On the record in the matter of the people of the state of Michigan versus Ariana Ash 24-03472. I'm sorry, 79, council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Ash, who is present. We're both present via Zoom.
Okay, Ms. Ash is the co-defendant in the Glasgow case, 24-03480. And this matter was scheduled for a probable cause conference today. And we waived the timeline previously. Set it for this date.
Judge, may I interject for one moment? Andrew
Yes.
Stevens on behalf of the people, I'm here for this.
Oh, okay.
The third defendant, Pharrell Morgan, was actually just in front of Judge Flores. I don't know if there's any way, I don't know if we can bring him into this room or not. Judge Flores held on to him as far as Zoom is concerned.
Okay,
Effectively, what Judge Flores says the court knows, the case was originally assigned to Judge Ward. Judge Flores is handling Judge Ward's cases this morning. And I tried to explain the circumstance, and Judge Flores advised me to head over to Your Honor.
well, that was perfect timing.
It was perfect timing, so that we could potentially discuss a date
Okay.
for preliminary examination, and as the court indicated, timing is sort of perfect. So I'd be happy to. I think he's in jail visit 2 or jail visit 2 post 4, something to that effect. So
If the jail can have him log into my courtroom with his attorney, who's his attorney?
Ms. Donnelly is stepping
Yeah.
in for Mr. Freeman, who was ill this morning.
Okay, let's see if we can have
Okay, so
him brought over here.
may I head next door to sort of help
Absolutely.
facilitate?
Thank you.
Judge.
I did find a note for the Hill matter, but if you'd like, Your Honor,
The Hill.
regarding that most recent conviction and possible probation.
I don't have a file right
Fair enough.
now. He must have taken. You say you found a note?
Yeah, of the last file that also indicates something about the county matter she was put
Oh,
on a term of probation for. So
sounds.
it seems she was on probation.
Okay, Nancy Johnson, we're gonna wait for that. Mr. Fightelson's on the phone.
Good morning, Your Honor.
Good morning.
I did meet with, I think we're ready with the first record. He is here.
And McDermit.
The lead, Miss Sutter, went downstairs to talk to him.
See if I got that.
Oh, sorry.
Yes.
Okay, back on the record, in the matter of the state of Michigan versus Alyssa Hill. Hill is on probation, correct?
No, I'm not. I finished my Eaton County probation. They revoked it, this year.
When was it revoked?
It was revoked over the summertime.
I see where you in March were sentenced to 24 months probation. And you mean to tell me it was already revoked?
Yeah, they revoked me. I'm not on probation. I haven't been on probation for like months now.
Okay, well, that's what I'm getting clarity on. I'm not disputing that you're not on probation. I'm expressing concern over the fact that very shortly after being put on a term of 24 months probation, it's already been revoked. And then we now have a new case, very serious felony charges pending against you. And Mr. Johnson, you're asking for what bond? You're muted.
10,000 cash surety, 10%, Your Honor.
And where is she going to reside?
My client can put her address on the record. She has an address in Ingham County.
Ms.
Ms.
Hill,
Hill? Ms. Hill?
Yes.
where's your
State-
address? Where are you gonna
state your
reside?
address.
817 Cleveland Street, Lansing, Michigan, 48906.
What's your phone number?
517-290-6596.
Are you employed?
Not right now.
Let's see. A bond will be amended to 10,000 cash surety with GPS tether. While out on bond, you're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. You're not to be at 6200 South Pennsylvania.
Okay.
You need to report to pretrial services in 48 hours of your release.
Okay.
Really? 48 hours is a holiday. You need to report to pretrial services by Monday.
Okay.
Thank you, Your Honor.
Do you have any questions for the court?
No,
Ms. Hill?
ma'am.
Any additional matters for the record?
Nothing from the people.
No, Your Honor. Thank you.
You're all set.
Thank you.
You're welcome. Okay, so I guess we're gonna log them in and maybe Judge Flores will give us the file.
Ask to walk it over if I'm allowed to do that.
Remember there was a time that they would let you take the file
Yeah.
and you.
And then there was a
note it?
time where you couldn't, and then there was a time that you could.
Yes.
I know.
Things-
There was a time I used to write in the file.
That's what I was gonna say, we used to, when I was at the city attorney's office, we wrote in the file what we did.
Our plea offers
Yeah.
and all the, yeah.
I don't know.
Casey? Is Stevens in there? I can't hear you.
Mr. Stevens is not in the courtroom at this time. He went to go get a file.
All right. Tell him to, Casey, when you see him, tell him to look at his email and respond back to me.
Okay, see, it got something on the screen. Hey,
Yeah. Oh, Lord. I don't even know.
stop. Okay. It's,
Because what would the last work day of the year be if it didn't have any drama?
I was good now, it's good now, it's good now.
So he just wanted to.
Young man, what's your name?
For real more.
Yeah, Mr. Stevens.
Are there things out in the hallway for Mr. Stevens? Correct?
Yes. Oh, okay. I think Mr. Carter wanted you to look at an email.
I saw it.
Okay.
And then that is Mr. Morgan, Mr. Glasgow. Ms. Donnelly is standing in for Mr. Morgan. I'm sorry, is standing in for Mr. Freeman, who represents Mr. Glasgow. Sorry, Mr. Morgan. This is why they put the logic games on the outset, Judge. There's Mr. Carter. We're waiting for Ms. Donnelly, who is finishing up something in Flores.
Sounds good.
You're just so on top of it.
That gives me a second to do what Mr. Carter said.
He's just in custody.
He's not just in custody, he's in custody all the way downstairs.
Bad word.
That's for a plea, we can,
Yeah.
We have a police here.
bring McDermott up.
Can I write the police sheet?
Yes, please.
Thank you.
McDermott.
I know. Sorry. No.
Her camera's just not on.
Oh, okay.
Oh, Ms. Donnelly?
No, Ash.
Oh, Ash is, yeah, Ash is here. Okay, I think we have everybody here. On the record, in the matters of the people of the state of Michigan versus Ariana Ash, that's 24-03479. People of the state of Michigan versus Trinitarian Glasgow, 24-03480. And then people of the state of Michigan versus Pharrell Morgan, 24-03575. Appearances, please.
Andrew Stevens on behalf of the people.
Case Mark Arian on behalf of
Joseph
Assistant
Yang,
Public, oh, go ahead, Ying.
Joseph Yang on behalf of Ms. Ash, we were both present via Zoom.
An Assistant Public Defender, Sarah Donnelly, on behalf of the defendant, Pharrell Morgan, who is appearing separately by video.
Please the court, David B. Carter Jr. on behalf of Mr. Glasgow. I am appearing by Zoom, and my client is appearing through the Washtenaw County Polycom, and we would waive our personal appearance and consent to this hearing through this media.
Oh, thank you. Today was the date that was set for probable cause conference. Both Ash and Glasgow was originally set before me, and Morgan set before Judge Ward. However, in her absence, being handled at least in part by Judge Flores. And these are a co-defendant case that needs an exam date, and then we will need to execute internal paperwork to transfer Morgan. Accurate?
Yes, Judge.
Okay. Let's see.
Your Honor, I do have to make a record of something.
I was going to ask about that. You can proceed at this time.
Thank you, Your Honor. The Public Defender's Office reached out to me to ask me to take Glasgow's case, which I did accept. After I accepted that, I would indicate that somebody on behalf of Mr. Morgan contacted my office seeking my representation for him. I've never had any conversations with Mr. Morgan, just a short conversation with a family member, not knowing this was the same case of this case. I did quote them a fee, and they never returned my phone call. I don't believe there's really a conflict going forward, but I believe I needed to cite that on the record.
Thank you. Counsel, did you want to respond?
No, Mr. Carter addressed this with me, and I agree with him, given what he's advised regarding the contacts and the communication. There doesn't appear to be any conflict, unless the court sees otherwise, but I appreciate that, Judge. Thank you.
Based on the information provided, I don't see presents a conflict based on that information. But we appreciate the candor in noting that on the record. Let's see. This was Mr. Morgan's originally scheduled probable cause conference. The timeline and the other matters were already waived. And so, Mr. Morgan, I'm going to advise you that you have the right in this matter because you're being charged with felonies to have a preliminary examination, and you have the right to have that exam within 21 days of the date that you are arraigned. Because this is a co-defendant case and in the interest of judicial economy and efficiency, the court is going to find good cause in your case to go beyond the 21 days because this needs to be set for a exam date so all three can run in tandem. Okay, sir?
Yes, ma'am.
I'm sorry, I didn't hear you.
Yes, ma'am.
Okay.
Well, so what you said it's gonna be waived 21 days?
Just the timeline is going to be waived because it needs to be reset.
Okay, so it's not December 27th no more?
It's not going to be scheduled on the 27th.
It's not?
It will not be on the 27th, sir. Okay, consolidation. I don't know here that this needs to be consolidated. Let's see. We're just picking a date. Any other issues or conflicts that we need to put on the record before we pick a date for an exam?
If I could just briefly, I have requested some additional discovery associated with the underlying matter that caused the traffic stop for Miss Ash. If I can get that at least a week before whatever date we pick, that should be sufficient time for me. I'm not sure what the timeline is from the people, but I would just take that into consideration. If I have at least 1 week, that should be sufficient for me. So
Sounds good.
The only thing I would indicate on behalf of the people, I personally am scheduled to start, whether, even though we're in conversations for resolution, start a homicide trial before Judge Kennedy on Wednesday, January 15th. So I don't know if the court was looking before that date or after that date. And then I would only add, I've been exchanging emails with Mr. Yang regarding his discovery request. Frankly, and personally, I thought by now he would have had that. And given what he said, it suggests that he has not, so I will work on that part. So he should get that pretty soon.
This is gonna take a full day. How long will this take?
I'd say a good chunk of the morning, not a full day.
Okay.
At least not in my opinion.
February 6th at 9:30.
February 6th at 9:30 work?
I will be in an attempted murder trial in Eaton County that day.
You can, obviously take.
On Tuesdays.
We have a small. Put this in mind. Is the trial for you?
15th of
The
January,
15th of January.
and then his was the 6th of February.
January 28th is a Tuesday. Does January 28th work? At 9:30?
That works for me.
I
Good on
believe
you.
that would work.
That's fine, Your Honor.
Okay, January 28th. At what time?
9:30.
At 9:30. And I'm certain Mr. Yang will have his issues as it relates to additional discovery resolved long before that. So any additional matters for the record at this time?
Nothing from the people, Judge. Thank you.
Nothing on behalf of Ms. Ash.
Nothing for Mr. Morgan.
Nothing from defendant Glasgow.
Chief bonds in each file will continue. You're all set.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you. Thank you.
We cancel the remainder of the document. Over that morning.
I don't know. She said, what do we have in the document?
We have a couple city cases, but they're before 9:30.
No, they're all before 9:30.
I'm good to go.
You're good to go, sir.
All
Thank you. And then I think Glasgow has another matter.
right.
Yeah, he has two.
Let me ask you
So the
this.
Morgan guy is on one of them is Ash.
Yeah.
Got it.
Excuse me, so I ain't got no court date on December 27th?
Yeah, I know.
So we're confused. We're doing both of those on the 22nd.
Which one?
Glasgow.
Yeah, I was gonna schedule both meetings.
Okay.
For the 28th.
January 28th. Yeah. You do not have a court date here on the 27th, sir.
Oh, okay, well, when would the next one be?
January 28th.
January 28th, all right, thank you.
You're welcome.
I'm
The
assuming
cost of
we're,
revenue.
I'm assuming we're gonna move the CCW case the same day.
The same day, yes.
Okay, so I'm good to leave.
Yes, thank you.
Thank you.
Thank you, Judge.
Thank you. Thank you for
Merry
your help.
Christmas.
Same to you. Did I write all the files? I did.
Okay.
Yes, there it is. I'm good.
On the record in the matter of the people of the state of Michigan versus Lamont McDermott, 24-02156, appearance please.
Good morning, Your Honor. Case Mark Aaron, appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. McDermott, who is standing to my right.
Mr. McDermott, you have a offer here from the people to plead guilty to the original charge of assault and battery. What's the point of the machine?
Just in case you needed it, Your Honor.
No, I never needed, if he's pleading straight up, there's not even a killabrew here, so that's the offer. You want to plead guilty to the charge? Raise your right hand. Do you solemnly swear or affirm the testimony you want to give is the truth and the whole truth under penalty of perjury? Put your hand down. Okay, you have the right in this matter to proceed to a jury trial. And you have the right to be presumed innocent. So that means, sir, you are innocent until proven guilty, and you can require that the prosecution move forward with the trial and prove each element of the charge of assault and battery beyond a reasonable doubt. You understand those rights? You could be silent at your trial and not have that silence be used against you. You have the right to waive silence and testify on your own behalf if you'd like. You have the right to have witnesses subpoenaed to testify for you. You have the right to see, hear, and question any other witnesses that the prosecution intends to call to testify. You understand that? These are all rights that you're willing to give up today in order to plead guilty. Are you on probation or on parole? You understand that a guilty plea could result in a conviction that you may need to report to your employer, or you might need to put this conviction on a future job application. It also could have impact on travel or immigration status. So you may seek to go on vacation somewhere out the country, and this could have impact on that. You understand that? Are you seeking to enter a guilty plea because you believe you're guilty?
Yes.
To assault and battery, how do you plead? Actual basis?
Thank you. Mr. McDermott, on or about February 22nd of 2024, were you present at or near 3900 Burnaway Drive? And is that in the city of Lansing, Ingham County, Michigan? And at that time, did you come into contact with a Terry Reed? Did that contact turn into an altercation of some sort? During that altercation, did you take or attempt to take something from his hand?
I did.
And that was against his wishes? Thank you, Your Honor. I believe that satisfies the factual basis.
People are satisfied with the factual basis as well.
Before he says that the factual basis, I'll accept your plea if I plea be made freely, voluntarily, and intelligently.
Your Honor, if I may briefly on sentencing.
Yes.
Thank you, Your Honor. Mr. McDermott currently has 85 days already served on this file. I would ask the court to consider sentencing today, since there's not going to be, I don't believe, probation at this point. Mr. McDermott would be rejecting probation since the time is already served. I understand a victim has the right to speak here, so if the court cannot do that today, I'd ask for sentencing to be set for January 23rd, which is the current time and date scheduled for Mr. McDermott's preliminary examination.
Your Honor, I have spoken with the victim on this case. He's been very on board the whole time, so I think I would request an opportunity for him to be heard at sentencing.
Since January 23rd at 9. January 23rd at 9 a.m. Prior to sentencing, you need to meet with our probation department. Actually, no, you don't. I'm not gonna put in probation. Sorry. Have how many days?
85, Your Honor. He's been in custody since September 27th.
FBR bond. Let's see, I amended this bond in November. Does not have 85 days. Yeah, and see, Magistrate Faulkner arraigned him September 27th. She gave him a $500 personal recognizance. You must have been, were you held on something else?
He has the felony file that's also scheduled for,
Yeah, it's likely I amended his bond because he was already in there, not getting any time.
I apologize, Your Honor, I had reached out to ICJ for some dates and I guess I missed some information there. I believe if the November 5th date is when his bond is amended here, it's at 46 days.
Still, like he's getting credit time served at the time of sentence.
Understood, Your Honor, my request would remain exactly the same.
Okay, so we'll continue to sentencing on January 23rd. Any additional matters for today's record?
Nothing from the people.
Nothing further, thank you.
Thank you.
Judge Rochelle, next week.
Um,
I think McCollum's the only thing we have left. I can go find Mr. Feigl.
Oh, because I don't know where Mr. Feigelson is.
He's been itching to go.
Mr. Austin is waiting for what?
Just waiting for some paperwork here.
For me? Oh, no.
There was a nollie cross submitted to the court on one of my cases.
I might have signed it. Oh, you want? Okay, let's see. And then Ms. Dixon,
Yes, good morning, Anna.
good morning. Which matter are you here for?
I'm here on behalf of the plaintiff Arrow Financial Services for case 1100456. Stacy Mason is the defendant.
Stacy
This is
Mason here? Oh, she's present in the courtroom.
Well, for Your Honor, you have a good rest of your weekend. and
Same to you.
Christmas is, I don't think I'll see you.
Same to you. Okay, let's see. This has to be-
So you don't see. Okay. Okay.
On the record in the matter, Arrow Financial versus Stacy Mason. This is file 11004556. And you can come forward. Counsel, can I have your appearance?
Yes, good morning, Your Honor. This is Natasha Dixon on behalf of the plaintiff. My PIN number is 82333.
You're Stacy Mason?
Yes, I am.
Who are you? Okay, are you a party on this?
Yeah,
I don't see your name.
well, they've taken our tax.
Were you named in this lawsuit, sir?
No.
Okay, you can have a seat back there.
They've been taking his,
Okay,
his,
well, he's got,
state income
he's
tax.
got to be named, okay?
Okay.
Okay, so this is an objection to a garnishment.
Yeah.
That you filed, you said that you're objecting to the garnishment because the funds are exempt, and that there was a bankruptcy
Yes.
not registered by a lawyer in 2011.
It wasn't in like 2011, it was in 2010, I believe, or we don't have the papers anymore, and the lawyer passed away, and did it.
You said the writ was not properly issued or otherwise invalid because I was insured at the time. Okay, can you explain to me why the funds are exempt?
Well, when I first called them, I was never served with any kind of papers. They just got started garnishing my wages.
I want to know why the funds are exempt. They're protected from garnishment by law.
Because when I first asked them what was going on, what they were taking the money for, they told me that it was for an anesthesiologist, a doctor.
Okay, so my question is very specific. You stated in your motion or your objection that the property is exempt or protected from garnishment by law. So you need to tell me what makes it protected by law. Meaning this is social security funds and the law say you can't garnish it. Like, this is what I mean. Why is it protected by law?
I don't remember putting that, but it'll be protected because we filed for bankruptcy.
Okay, so that's the second thing you put. You filed for bankruptcy in 2011, you said?
No, we filed for bankruptcy in 2010 or 2009.
And you believe that this debt was discharged as part of that
Yes,
bankruptcy?
we were totally clear of everything.
Okay, where's the information about the bankruptcy?
We don't have it any longer, and like I said, the lawyer has passed away, and we can't get a hold of anybody that has the information.
Well, if you filed the bankruptcy court would have record.
Bankruptcy court. So we don't know how to do that. How to get,
Okay, so what do you expecting me to do if you can't provide me with proof?
well, what I wanna know is why they keep telling us it's for different things. Now she's saying it's for a Washington Mutual Bank for a credit card. Before it was for an anesthesiologist, and now it's for a credit card that I don't ever remember getting a credit card.
Is that why you put, I wasn't sure at the time, is because your belief is this is about a medical debt?
Yeah,
Okay,
I'm changing it on me.
okay. What is this debt for, ma'am?
Yes, Judge, this is for a credit card, and I had spoken, it's for, the original creditor was Washington Mutual Bank, and as it's common, the debt was assigned to my client, Arrow Financial Services. So I'm not sure where she's talking about the medical, because I'm looking through our records, Judge, and I don't see that we have spoken to her prior to this. So I'm not sure who mentioned that to her as far as the medical, but it's not a medical related service, basically.
Does that answer your question about that, ma'am?
Yeah, but it's not true. This was in 2003
What was in 2003?
when this happened, when they're saying this all happened.
I don't know what was, I don't have any record of 2003. I know that there was a judgment in here, I believe, since 2011.
Yeah, but they're saying that I opened a credit card or the anesthesiologist, that's all happened in 2003.
I don't know that an anesthesiology issue is related to this credit card. You might be mixing issues, maybe? Yeah, this is about a credit card debt that the ownership of the credit or the debt is now Arrow Financial Services, so they're trying to collect on that outstanding debt. You would need to provide some proof that this was a debt that was discharged as part of your bankruptcy filing. Otherwise, there's nothing I can do.
Okay, can I have some time to get that together?
I'm going to deny your motion, and when you find the proof, you can refile the objection.
Okay, isn't there like a statute of limitations or time limit that?
To do what?
They just keep
To collect
taking my
on the
money
debt?
forever?
No, the way the statute works here, and they're within the statute of limitations, if that statute runs, or the judgment gets old, 10 years, they just file, as long as they file a request within that time period to renew the civil judgment, then the law allows them to renew it.
Just go on and on and on. Wow. Okay, so we need proof of the bankruptcy.
Absolutely. If you filed a bankruptcy in 2010, 2011, and you believe this was discharged, then your records, they didn't die because the attorney who handled it dies. The records are still there forever. And you should have received proof or some record that it was discharged. So you would need to go to the bankruptcy court and get a copy of that record. Okay?
All right.
And then when you file if you come back to file another objection, you would select the one that says it was discharged in bankruptcy, and then just attach a copy of the proof so that they can get a copy of it, okay? Any additional matters for the record today, counsel?
No, Judge, thank you.
Thank you, you're all set.
Thank you.
Thank you, Judge.
What happened to McCollum?
I didn't know if you wanted to get.
Oh, we're ready for McCollum.
For Trinitarian Glasgow's files, do you have those or anything? Notices in there.
Yeah, I have them. I just need them back. I'm gonna make sure they consolidate the one that was before.
That's what he told me. I was like, yeah.
My brother, the golf game is an option. He did the first tee. He's like, he's pretty convenient. Before I bounce, before I get to the green.
It's much better. I wish I started doing those younger. I didn't do that.
You know, they used to drag me to this first tee stuff when I was a kid. I just hated it. Because it was.
Yeah.
Oh, nice. Here I am now.
I got wrapped up in other sports.
It matters so much with that sport too. Like your whole swing.
Yeah. Funny, you always have.
My brother's good. He competed in a couple state championships. I think he got third.
Surprising Andy doesn't golf.
He does, I think.
I bet he's good at baseball.
I've never talked about it, but I would assume.
Yeah. Hockey.
Yeah.
Dragons. That's what I think.
Everybody just can't take the day off.
No. I wish we could. But
Stop doing bad stuff for one day.
maybe we have to.
I know. Oh, really?
Yeah. It's not that bad. I like it. We used to come here, they used to give us donuts. It was so nice. It's probably good. Of course, so much. So I was like, taking out a quick deal. Oh, is it? You gotta stack me. I have no idea, but I'm getting used to the I like a little bit of both. Like if I need to just get something done, I can.
I like working one day. I would get too lazy if
I would miss the
I would just start doing a degree. I would just start watching TV. But one day where I just have to start practically.
See, when I studied for exams in college and law school, I had the TV on, so I'm used to it together.
Yeah, I do that too, but like, I'm almost more productive at home. So. Going anywhere for the holidays, Judge?
No, my mom got here yesterday.
You got here? Okay, I didn't know if you had to go see her.
On the record, in the matters of the people of the state of Michigan versus Quandell McCullum, I have file number 24-0346 and then 23-03167.
Morning, Your Honor. Case Mark Perry, and appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Quandell McCollum standing to my right this morning.
Okay, Mr. McCullum, today was the date that we got continued to do an argument from your attorney and a determination as to bind over on this file. Any preliminary matters before we continue?
I'm from the people.
Nothing on behalf of Mr. McCollum, Your Honor.
You can make your argument. You can have a seat, Mr. McCullum.
Thank you, Your Honor. Talk about a couple of things. I will start with the file in regards to the GBH matter, Your Honor. Let's talk about a couple of things. We heard testimony last week from Officer Fox. Like with the Lansing Police Department. I want to talk about one big area that I think it is relevant. He testified under oath that he tackled Mr. McCollum during this exchange. Later in that examination, we heard testimony from another officer, an officer who said Mr. McCollum did run from me, but nobody tackled him. Gene, after he ran, he peacefully surrendered himself. So it's a big distinction from Officer Fox's testimony. Why that's relevant is we didn't hear from the alleged victim in this case. They're relying on the domestic violence hearsay statute in order to allow that all those things to come in. The one big element they need to show is the veracity of the law enforcement office. Made a pretty big misrepresentation of what happened with regards to the arrest of Mr. McCollum. So I think that's worth pointing out. I want to talk about a couple other things in regards to Officer Fox's testimony. Mr. Fox said he took a statement from him about where he found a knife, yet that statement never made the report. So how do we know everything that Ms. James said to Mr. Fox is accurate when said under oath, I make accurate, complete police reports, yet it wasn't. And then blatantly made a misrepresentation to the court about tackling the defendant. So let's look at, can't dispute the picture showing an injury. Okay. Whether there's any evidence that he threatened to kill her enough to make this an A-limb.
You say killer enough?
Is there enough evidence to suggest that he made those statements to Miss James? I don't know, and that's the issue that I take with this. If you look at the case law, Your Honor, the facts in this case are different than those cases, and the one big difference is we didn't hear from the alleged victim in this case. Now let's look at the interfering with the electronic communications. We heard testimony from Officer Rincon that he found the phone in my client's pocket, yet that also never made his police report. We don't know when he got that phone, but no evidence to suggest he took it in the process of her calling the police. We know the police were called. The phone proves that he showed up that night. I don't think there's enough evidence to suggest that that occurred at a probable cause standard. So I would ask that those two charges not be found over. With regards to the home invasion, Your Honor, again, we heard nothing from Miss James. We did hear from Miss James' mother, who testified that she had just woken up, had just gotten out of the hospital from some significant injuries, and says she witnessed all of this. I'm not certain that I take her to be completely credible in regards to the home invasion or other witnesses present. We don't know if any of their statements were taken from law enforcement. We didn't hear from Miss James. She wasn't here. I don't think there's enough evidence to bind that matter over, Your Honor. Thank you.
Yes, Your Honor. First, I'll just note for the court, I do have all of the exhibits that we admitted to, Your Honor. Would like to reference any of those. That's People's Exhibits 1 through 7. Regarding the assertions that Officer Fox misrepresented himself for the testimony or anything that happened, Your Honor, I probably would have objected if a jury was here. I'll state my objection formally on the record now, as that being a mischaracterization of the testimony. To be clear, what Officer Fox said was that he was an assist officer who showed up, observed the foot pursuit, and believed he saw Officer Bynum tackle Mr. McCollum to the ground. Then at that point, we had Officer Nicholas Rincon, who actually was involved in the foot pursuit and right behind Bynum, clear up that he wasn't ever actually tackled. So I don't know if we really have a misrepresentation here or if that has anything to do with the credibility of the victim's statement on this case. Not only that, but additionally, there are references, as I believe we cleared up with the testimony of Officer Fox, to the knife in his police report very clearly. So the description of the knife was given on the record and included in his report, as well as the documented statement. We have the photos consistent with everything that happened for corroboration of these statements being verifiable and true. I understand the argument about not documenting in his report as Officer Rincon that he recovered the phone from the defendant's pocket, but he testified under oath that we have a photograph to attempted murder. I think there's more than enough to bind them over on all the charges that I've asked for. Also, Your Honor, I would lastly remind the court that we did take testimony from Detective Stephanie Kennedy at the first date for this preliminary exam, and it was then continued, at which point Detective Stephanie Kennedy did testify to the statements that Tamaris James gave regarding the home invasion Bible. So we do have victim statements from that too. We also have testimony from Detective Stephanie Kennedy of approximately 300 phone calls, along with messages made by this defendant to Tamaris James from jail that he already entered a guilty plea to, Your Honor. So it's not really lost on me why Tamaris might not be here with us today. With that, I'll stop. Thank you.
That's course of the matter. Huh? That's not the name of my doctor. Yeah. And you have requested again to add and file number 24-0346, assault with intent to murder, correct?
Correct, Your Honor. My specific request was to add it as a new count one with those two GVH charges that are already charged in the alternative to that.
Okay,
Primarily, I think the intent is proven by the defendant's quote of might as well get this over with after already assaulting Ms. James with.
okay, today was the date and the time that was set for the continuation of preliminary examination on both of these files. The burden is squarely upon the prosecution to establish that they have sufficient probable cause that these felonies were committed and probable cause sufficient to charge you with those felonies. So this is not a trial. They don't need to prove each element beyond a reasonable doubt. They just need to provide more than mere suspicion that the crime alleged has occurred. And so the determiner of credibility solely is the court at this time. It can be based on circumstantial evidence, but it's based on the circumstances as presented at the hearing, which has gone on for a span of 2 different days at this point. We previously took a testimony from a witness, Shanetta Beasley. She testified that she is the mother of a Tamaris James. She wasn't sure why Ms. James was not present at the date and time in question. She testified that Ms. James had been receiving some medical treatment and had been stabbed about 5 times. She believed that there was some facial disfigurement, burnt marks to her face, throat, fingers, and that she had been hospitalized for some period of time. And she reported that her daughter suffered some what she believed to be permanent damage to her right eye due to being stabbed. She stated that on the date and time in question of May 24, 2023, that there was damage done to her home by the person she identified as the defendant, Quandale McCullum, at the area of 1412 Georgetown in apartment B, I believe. She also testified that on another date and time in question that at 5 a.m. Well, she also testified that at 5 a.m. the date and time in question that she woke up to a shatter, something breaking, and that she could see the defendant's body hanging halfway in and out of the window. That she had just been released from the hospital. She was in a hospital bed in the other room. She recognized the defendant's face, and that she said that her daughter and someone that she identifies as her son-in-law were in the room involved in a tussling or pulling between Mr. McCullum. She saw the defendant in her house before, and that's how she was able to identify the defendant for this purposes. And that she said the defendant was trying to get after her daughter, is how she termed it. She said she doesn't believe the defendant saw the other person, that person being a male that was in the room, that the defendant never opened his mouth or never said anything. And that she believed the defendant was trying to pull the daughter out of the window. Can I have those exhibits too, which were admitted by stipulation? A testimony from Officer Fox, who reporting to the area of 1904 Georgetown Boulevard, Ingham County, on or about August 10th, 2024, that he made contact with the accused, Mr. McCollum. He said he was responding to an act of domestic violence, and that there was a statement made that glass was heard shattering, and someone was running. He heard the officer Rincon ordered a lawful commands for the subject to stop. There was a foot pursuit, and the subject was later apprehended and taken into custody, and that he returned to the address to look for evidence of the crime. Testimony was given in court by Officer Fox admitted under 76827C. And he testified that the victim Ms. Tamaris James appeared to be visibly shaken, crying. She was covered in blood. She stated that the incident had started about 10 to 15 minutes prior to the police arriving, that they were arguing and the defendant slapped her. She slapped him back. The defendant grabbed her by the esophagus, punching her in the neck. The defendant left the room, went to get or grab a kitchen knife, and was hitting her with the flat side and stabbing her with the tip as he slammed her on the ground and stabbed her while holding her on the ground by her neck. And she used her legs to try to push him off of her. The accused came out and tossed the knife at the sink. Victim had a bleeding wounds from her head. And she had been stabbed at the top of her head. That there was also testimony from Officer Nicholas Rincon, who said he heard a loud noise. Said that the victim said she had a loud noise, knock at the door. The female was in distress. 3 people came to the door. Somehow, someone yelled, he stabbed her. There was a black male with his hands up, and that he identified visible injuries and blood on the victim. Officer attempted to detain the suspect. The defendant yanked his arms and ran. There was a chase and he was taken into custody. The officers located a cell phone in his pocket. It believes the cell phone was taken by the accused to prevent 911 calls. There was testimony that indicated that there was shown on the screen attempts to make emergency phone calls during the time, around the time in question. The home invasion, first degree, at the time of trial will require that the people prove beyond a reasonable doubt first that the defendant broke into a dwelling. It doesn't matter whether anything was actually broken. However, some force must have been used. Opening of the door, raising a window, or taking off of the screen are all examples of enough force to count as a breaking, entering a dwelling through a already open door or window without using any force does not count as a breaking. Second, the defendant entered the dwelling. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling after the breaking, that is enough to count as an entry. Third, that the defendant entered, and in this particular case, or the defendant broke into the dwelling, and when the defendant entered, that was entered, present in, or was leaving the dwelling, that in this case, Ms. Tamaris James was present in it. Fourth, that the defendant was present or leaving dwelling, either the following circumstances existed, that he was either armed with a dangerous weapon or another person was lawfully present in the dwelling, which again would have been Ms. Tamaris James for the allegation. The court heard the testimony of Shanetta Beasley about the allegation of the breaking and entering on May 24th, 2023, and that she could physically see Mr. McCullum halfway through the window attempting to pull her daughter out. The court is satisfied with the factual basis as to count 1 for that file, home invasion first degree, that will be bound over to the circuit court. The other file we have count 1, assault with intent to do great bodily harm less than murder, and count 4 by strangulation, which is the same count for count 2. The people are requesting to add a new count 1, making, and the alternative, an assault with intent to murder. There was case law that was provided and argued at the time of bind over, but also provided so that the court and defense counsel can have an opportunity to review that case law to determine sufficiency of evidence to rely upon the request to add this additional count of assault with intent to murder. And by nature of the review of that, the court is satisfied that, as argued by the prosecutor, that the court is of the belief that the sufficiency of evidence was sufficient to request an additional charge added of assault with intent to murder. The jury instructions for that would require the people to prove at trial first, the defendant tried to physically injure another person. Second, when the defendant committed the assault, he had the ability to cause an injury, or at least believed he had the ability. Third, the defendant intended to kill the person he assaulted. And it says, and the circumstances did not legally excuse or reduce the crime. And in the statements provided by the officer, in the absence of Miss James, not only was there a description of assault or allegations of assault with a weapon, that being a knife, a kitchen knife. The court reviewed exhibits 1, 3, 4, 5, 6, and 7, which those exhibits demonstrate not just the allegation of injury caused to the person identified as Miss James in this, but there's blood strewn all throughout the property, all over the carpet. It looks like on the bottom of shoes, on a dresser. It's blood splatter everywhere. And then statements that were made to the officer, which were then made in court, particularly the statement that we might as well get this done, as the defendant allegedly is holding Miss James down by her neck or esophagus, however it was termed, and using a knife to wound her and stab her allegedly, and whatever else was used to cause the burn marks that were also noted. The court is satisfied that there is sufficient probable cause as to assault with intent to murder, that intent being satisfied by the allegations of the statement made while using the knife, which was the weapon in this case. So a new count one will be added, or I should say amended, to assault with intent to murder. Count 2 and 3 will now be assault with intent to do great bodily harm less than murder or by strangulation, and that will be charged in the alternative to count 1. Again, there were statements made through 27C of being held down or grabbed by her throat and or esophagus, and being assaulted by Mr. McCullum at the date and time of that incident. That testimony also about Mr. McCullum fleeing or eluding or obstructing the officer from their ability to perform their functions when trying to take him into custody. I recognize, Mr. Iverson, you have a dispute about the credibility of the officer, of Officer Fox, because his version of the events didn't completely align with what you believe the responding officer's version was. However, the court is satisfied that even if there was some inconsistency, I don't believe it was enough for the court to believe that that inconsistency rose to the level of a lack of credibility. I found his testimony to be credible. Both he and Officer Rincon testified to a pursuit of some sort. And also the defendant yanked his arms when being taken into custody and ran, that he was chased and then later taken into custody. As the court will bind over as to count 3. Count 3 now becoming the new count 4. Count 5, which will now be the new count 6, interfering with electronic communication. Again, we can rely on probable cause. We can rely on circumstantial evidence to establish the probable cause. When I look at the People's Exhibit 2 and I see telephone at 5:50 that the officer said that they located in the defendant's pocket when they taking him into custody, and I see there's several missed calls, one at 5:19 in the morning, emergency call, and another one at 5:25 in the morning, an emergency call. And then even it looks like a missed call in between there, or a block call. It's reasonable to believe that someone was trying to make a 911 call and that those calls were intercepted and that phone was found in the defendant's pocket. We're satisfied as to that new count 6 that will be bound over to the circuit court. Amended complaint may be required. I'm not sure, Mr. Markarian, but each count will be bound over for bind over date of January 8th. That's the date the circuit court's going to get the file from. If you interrupt me, then we will not continue in this form. I will give you an opportunity to ask your questions, but it's not while I'm talking. Do you understand that? Okay. And so bind over date is January 8th. That's the date the circuit court gets the file from the district court. That is not a date you, Mr. McCullough, need to be in the circuit court. Your next court date will be at circuit court. It will be a pretrial and your attorney will be made aware of that date. Do you have any questions about that?
That's all I just want to put on the record. Try to get a new attorney, my rights. I wouldn't been able to get a new attorney because I've been told I couldn't use a phone. So I just want my privileges back so I can be able to get my phone. I want that to be stated on the record because I cannot get a new attorney. And I had said this, and it's a lot that I had that I wanted to be presented that he did not. So he was not ready. And I go back to say that. Yeah. I just want to leave to appeal. I want that to be put on the record.
Okay, your record has been noted. Your phone privileges have been revoked because of the
a lie.
Because of the.
And
we'll deal with some contempt if you don't let me conduct my time. Just the way I let you have an opportunity to speak and I didn't interrupt you, I expect the same respect when I'm speaking. And I don't care if you are annoyed or frustrated, that's reasonable, but that doesn't mean you get to be disrespectful and disturb the order. And so I also have, just the way I let you make a record, I need to make a record. And the record's going to also be reflective of the history of these files. The phone privileges were revoked after allegations were made that there were over 227 phone calls in violation of a no contact order from the Ingham County Jail, which is reported to the protected party, who then doesn't appear to court for the time and date set to proceed in a hearing. You waived the right to have that hearing. You could have had that hearing and evidence could have been presented in court to establish the allegations of the 227 calls. But you pled guilty to making contact in violation of the no contact order. Appeal that. Because as long as you are violating the contact order, making calls to a protected party, I will always restrict and limit your ability to make the phone calls because you can't restrict and limit yourself. No, at no time did this court revoke your privileges to talk to your attorney. In fact, if I look at my note from August 22nd, when I revoked your privileges, jail privileges revoked, no calls, video, visits, or emails other than to an attorney. No one has restricted your ability to get a new counsel. What we did restrict is your ability to use your family to make third-party phone calls to possible have witness interference, which was the allegations that you pled guilty to. Any additional matters for today's record?
For clarity of the record, Your Honor, I did request an added count of felonious assault on this file. I think it would now be a count 7. I would just request Your Honor to make a ruling on that.
The request for an added count
It'll be a count
7 of felonious assault was granted. I didn't say it on the record. It is granted and it will be added. I know we're gonna need a new complaint.
Yes, Your Honor, I'll get that prepared.
Thank you.
Nothing further from the people.
You're welcome. Anything from you?
Just one thing, Your Honor, I just want to correct something you mentioned, that it's pled guilty to the witness interfering. I think they'll just do a bond violation.
I didn't say with witness,
Excuse me.
guilty to witness interference. He pled guilty to a bond violation.
I must have misheard you. I apologize.
Correct. You don't want to address the fact that he's saying that you have not done your job.
I will in a second, Your Honor. That's completely inaccurate. We had discussions about what he wanted to articulate, some of which, as I indicated to him, were things we would have to raise at the trial court. And some of what he wanted, I incorporated, Your Honor. We've spent numerous times meeting together. I met with him downstairs, lock up this morning. I met with him yesterday. We've had numerous deal. Phone, emails. I met with him last week to discuss the offer. He's gonna say what he wants to say, Judge.
I recognize that a lot of times it's difficult as a defense attorney to explain the process and what time is appropriate to present defenses. This is a preliminary examination, so not always the best time to present. And how do you present it unless you put someone there, likely him, which probably is not a good move for you at this juncture. But that's a part of strategy that he gets to decide. The defendant does not get to decide the strategy, nor does it rise to the level of ineffective assistance of counsel if he doesn't listen to your strategy. Unless you can present to the court that you have a law degree and you've been practicing for longer than he has, and that you are more competent in legal procedure, you don't get to tell him how to do the job. You do, however, have the right to hire your own attorney if you don't like the public defender's representation, but you don't get to decide that you're going to get a different public defender. Do you understand that?
Yes, Your Honor.
So you can hire an attorney and they'll file their substitution over at the circuit court. Bond in this file is 150,000 cash surety. That will continue. There's a 75,000 cash surety bond on the home invasion. That will continue. I don't believe that he was sentenced on the bond violations.
I think what he's asking, Judge, because of the phone privilege being restricted, it's been difficult for him to be able to make contact with private counsel. Is that what you're saying, Mr. McCall?
Yes, Your Honor. I haven't been able to, if I either wanted new counsel, since I can't contact or use my phone privileges or anything, I can't use the phone, so how can I be able to get new
Your
counsel?
phone privilege is supposed to be allowing you to make contact with an attorney.
No, the jail, I understand what you're saying, Your Honor, but the jail will not let me get on the phone at all because he's saying that I have been on the blacklist where I can't use no communication at all. And like my family and everybody will give me an attorney or at least try, but I can't talk to nobody.
No, you can't talk to nobody by phone. They can come up and visit you.
Nobody comes to visit me. They don't set it like that no more. You gotta do it over the tablet, over the kiosk machine. So my visits has been tough. Nobody can visit me. Nobody can visit me. I can't message nobody. I can't call nobody. The only person I can message was him. That's it.
Counsel.
Yes, Your Honor, if I may. I don't know if the jail maybe took some own action on their own. Perhaps they did, because frankly, the allegations in this were that over 200 calls had been placed from his account. We called the jail to have his privileges revoked out of an abundance of caution and to protect the victim on this case because of that. They did that temporarily until Your Honor granted an order to follow. This defendant then found 4 different inmates' accounts to then use to try to circumvent that system. He's also been sending e-messages. He's also been attempting video visits on top of those almost 300 calls. So whatever the jails decided to do with them at this point in terms of a blacklist is something that they did on their own accord. Your Honor made her orders very clear that he was allowed to communicate with an attorney still, but no one else. if he hasn't made efforts to communicate with attorneys to seek counsel, if he was upset with what Mr. Feigelson had done, then that's on him, frankly. What was extended and what was communicated through Mr. Feigelson to his client was a very fair offer that I begrudgingly gave on this case due to the victim's failure to cooperate based on his phone calls, due to Ms. Shanetta Beasley being gracious enough to understand that a plea resolution might be better for everyone involved. To be clear, what this defendant was offered was to plead to one count of assault with intent to do great bodily harm, one count of aggravated domestic violence with a habitual second offender notice instead of a habitual fourth. In exchange, we were dismissing another count of assault with intent to do great bodily harm, resisting an obstruction, interference with an electronic communication, a home invasion first with a have fourth, which is a life offense by itself entirely. That offer was communicated to him. Mr. Feigelson drove to the Mason jail to see him in person to communicate this offer to him. He declined. That's his choice. When he declined, I made him aware through Mr. Feigelson that I was going to seek to add assault with intent to murder, that I was going to seek to add felonious assault. He has made his own bet at this point, and he can lie.
There's an on-site visitation schedule, and then there's a remote visitation schedule. The court has not removed your ability to have visits on site.
Your Honor, I can't even at all. No visits at all. So with the prosecutor attorney saying, I understand whatever.
We've not limited your visitation schedule.
That's what they saying to you. They saying because you called up there.
I didn't call anybody.
The clerk.
I didn't call nobody.
Well, the clerk or whoever came from.
The clerk didn't call anybody. We
They
entered an
said
order.
that the judge have called up here and took my rights. So since it took you left, that's what they're saying.
If somebody told you that I called or anybody in the clerk's office called and did that, then they are telling you an untruth. We didn't call anybody. We entered an order. My order stated that your jail phone calls and video visits were limited because of you're violating the order. That's the order of the court, and that order is going to continue. Any additional matters for the record?
I still think we have the sentencing and the bond.
I believe he's been in custody since August.
Correct.
Current time, sir.
Thank you.
Thank you.
And I will add that offer was communicated before we started examining.
That he did object on the record.
Okay.
Thank you. It's all set.
I'll work.
Let's see, is it Stucra,
Judge Hamilton, how would you
have a good one.
Good morning, Attorney Stuckroth here.
Okay, I see Carmen's iPhone.
Merry Christmas.
I do believe that's Miss Fahey. She was chatting, using the chat feature to kind of alert the court as well as myself that she is here.
Miss Floyd,
Uh-oh.
she's not here
I do
anymore.
think she was having some tech issues.
Okay, we'll see if she logged back in.
Okay. Miss Fahey, if you're on your cell phone, press *6 to unmute.
Miss
Okay,
Floyd?
hi, we're here. We're here.
Okay, thank you.
Michaela,
Yeah, next week, Judge, so.
Okay,
yep,
Yeah,
we're
good
here.
meeting.
We're ready to proceed again.
have a good one.
For your holiday.
Same
Okay.
to you.
Good one.
Michaela. Hi, we're here.
Done.
Yeah.
Okay,
Have a good one, Judge.
have a good one. Thank you.
Thank you.
I do with my docket. How was that? Okay, this is a pre-trial. I'm gonna put you both in a private meeting room.
Okay.
Michaela's, this way, Michaela is with you.
Yep. I drove to her work, Judge Simmons.
Okay, I'm gonna put you in a private meeting room so you all can do the joint pre-trial statement. Counsel, did you get a copy of?
Excuse me?
I don't know that I was, well, no, I take that back. I think I have. In any event, more likely, this will likely be resolved, I hope, in the breakout room.
Okay, you either can complete a joint pre-trial statement or resolve the matter.
Understood.
Let me see, room 1.
I can see, right? So my tooth are so fine. Where you getting some from? Shit. I'm mad at you. I get that. Okay, we undid it though. Oh, my image does not kill me. Oops. Leave it alone. I was just gonna put the mute on. Okay.
Okay, Michaela Foy,
Yes.
okay. Mr. Stuker, did you meet with Miss Michaela Foy?
Yes, we did, and we did reach an agreement via conditional dismissal. I don't know if the court wants us to put that on the record. However, I did obtain Ms. Foy's email address so that that can get circulated for her signature.
Okay. Okay, so you're gonna do a conditional dismissal. You're gonna circulate it for her review and signature. I don't see her anymore. Ms. Foy, are you still there?
Yes.
Okay.
I think she
And so
might be
that's
in a
all you-
bad spot for connectivity, so I know
Okay,
if you
so-
turn off your camera, it still works.
Okay, so you are gonna do a conditional dismissal. You can do one of two things. He can circulate it to you for your review or signature. I can put it on the record and you can give him permission to sign on your behalf and then he can file it. Which one do you want to do?
That's fine.
Okay, and this is the matter of BCG Equities versus Michaela Foy, 24-04537. Council can have your appearance.
Good morning, Your Honor. Attorney Richard Stuckroth appears for the plaintiff BCG Equities LLC, P85814.
Okay, and then Ms. Michaela Foy is present via Zoom today with the date set for pretrial. This is a general civil matter. The parties have entered into a conditional dismissal. Council, please put the terms on the record.
Absolutely. Thank you, Your Honor. The parties have agreed to a balance of $2,600 that will be repaid via monthly installments of $216 per month on the 15th day of each month. Payments shall begin on February 15th of 2025 and again continue on the 15th day of each month thereafter until that balance has been repaid.
Ms. Foy, that's accurate and complete as to how you want to resolve this matter?
Yes.
Okay, and do you give a counsel for the plaintiff permission to sign a conditional dismissal with those terms?
Yes.
Okay, so counsel, you can sign that with her permission and file that through my file. Do you have any questions for the court today, Ms. Foy?
No, ma'am.
Any additional matters for the record, counsel?
Copy. Can I get a copy?
Just
Please.
one logistic thing for the court. Ms. Fahy did provide an updated address while we were in the breakout room. If we could update the court with that.
Yes, what is your address?
2387 Cedar Street, apartment 8, Holt, Michigan, 48843.
Okay, we'll have a copy mailed to you.
Thank you.
Thank you. Any additional matters for the record?
No, Your Honor, and Ms. Fahy, there should already be a copy of the proposal in your email inbox.
Okay, and then as far as like for the payment plan, like how will I?
That's included in the cover letter in your email inbox.
Okay.
That's pronounced Foy, correct?
Yes, like FOY.
Oh, boy.
Thank you. Thank you. You're all set. Thank you.
Thank you.
Thank you very much.
Mm-hmm.